Hey everyone, Harry here to talk about yet another last-ditch effort by Trump to try somehow, anyhow, whatever could possibly work, throw against the wall and see what sticks, motion, or in this case actually a letter, to challenge the New York 34 convictions from the trial in Judge Merchan's courtroom. Okay, I've got a Substack today, actually, that talks about the last effort that Merchan just denied involving a challenge based on supposedly introduction of immune evidence at the trial and Trump's really unhinged, over-the-top rant that sounds like a mentally ill patient, that the judge is psychotic. This would mean the end of the presidency as we know it. It's completely unconstitutional. Of course, he has no idea, of course, what he's talking about, but the volume is doubled and redoubled. And it occurred to me, it's developed more in the Substack, that whatever grievance is there, he has been phenomenally successful in getting rid of 98%, 95% of his big profile of potential criminal liability. But that 2% so rankles. And I think if it were a little bit more, a little bit less, that's just his MO. And he goes into complete rhetorical overdrive. I mean, really, it seems almost cartoon-like that he's just gonna, turn around and be like all springs bursting out of his body. Okay, but this never say die effort is anomalous, to say the least. It's supposedly based on juror misconduct. And the hint is that it's misconduct that occurred during deliberations. Now, Trump team sent a letter about this, and Merchan released the letter in heavily redacted form because of concern over dangers to the jurors, which, again, take a step back. The man is about to be president of the United States, and if you would reveal the juror's name, they would be in danger. And the same thing with the response from Bragg's office, mainly redacted. But it seems that Trump is very much trying to eat his cake and have it too by suggesting on what Merchan called mere hearsay, mere conjecture, that there was some kind of misconduct or juror impropriety in the deliberations, but trying not to have a hearing about this, which is the way, of course, you would figure it out, with what sounds like a pretty thin excuse that, that part, a hearing, that would get in the way of, you guessed it, Trump's preparation to ascend to the weighty responsibilities to which the American people have elected him. So they want to sort of dirty this up or have some kind of suggestion that something went awry, but literally not subject it to proof. Now, there's some suggestion in one of the pieces covering this letter that Trump thought that maybe he would have a juror affidavit from another juror perhaps to add to it, and that didn't happen, and so they need now to simply go on unsupported hearsay because an evidentiary hearing would go awry. And that actually could be why it's a letter, not a filing, because an actual filing before the court, you have to have facts supporting any allegation. It's an ethical obligation of a lawyer. So it could be that the lawyers shied away from making scattershot or ill-founded allegations without any kind of backing. That's what the whiff of the whole thing is to me, that they had hoped they would get more support. They didn't get that support, so now it's a bare bones allegation. They must know that a judge can't take a letter like that saying there was juror misconduct and rule on that basis. Yet they are resisting a hearing. So the DA quite properly says, they're coming forward, but give no evidence. Let's have a hearing, or else they, put up or shut up. And they are resisting that somehow. So the whole thing just doesn't get out of the box. And Mayor Chun rules that juror misconduct is serious allegation, but I can't do anything with mere hearsay or conjecture. So I guess opening the possibility for Trump to come forward with more, including in a filing, but I don't think it's there. We'll see. And it just stands now as a kind of another empty Trumpian maneuver that they must have known that judge couldn't possibly have granted or done anything on the basis of, but it's another, I guess, PR move that is aimed to have the American people to think ill of the prosecution. Maybe they're bowing to the strong possibility that it doesn't go away. So the next thing to do is try to trash it or suggest it was corrupt in many different ways. And recall, of course, after Mayor Chun's denial of his last motion, Trump went berserk and, called it, as I said, all these many things. So it's a sort of secondary PR strategy, perhaps, to just try to really disparage the trial and make the American people, or half of them, or 42% of them, or whatever, think that the whole thing was bogus. Of course, I was there, and anyone who was there will tell you it's not bogus. It wasn't the case of the century, but there's no sense in which it was somehow contrived or not bona fide. It was a violation under New York state law based on the great wealth of evidence that was there. But it's his singular battle right now, it seems, in advance of taking office, to do whatever he can, either to rub it from the pages of history or just cabin it in the mind of the American people as some kind of, political aberration that made him a victim rather than a felon, which the New York jury decided he was 34 times over. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.